Well, hello, I'm Janet Morana, Executive Director of Priest 5. Welcome to Just Ask Janet. Of course, I'm joined today. My guest is our National Director, Father Frank Pavone. Welcome to the program, Father.
Good to be here.
And of course, Father, there is so much going on right now and hope for the pro-life movement. So many people, I think, Father, are discouraged because we have Biden in the White House, pro-abort Democrat there, Nancy Pelosi and all them controlling the House, and Chuck Schumer and his gang, the Senate. So they feel like, what progress are we going to make? Well, the progress we're about to talk about today is in the courts. It's the Supreme Court, isn't it, Father?
Well, it's progress we already made. And we told people when we elected President Trump, we said, the justices he's going to put on the Supreme Court, that lasts way beyond his presidency.
Right.
And all the other federal judges he put, hundreds of them, last way beyond his presidency. So now we're beyond his first term. And the good effect is lasting because now the court has accepted this major case on abortion, the Dobbs versus Jackson Women's Health Organization. And it has the potential of reversing Roe v. Wade altogether.
So before we talk of the case, let's just talk about the justices for a minute, because not everyone off the top of their head, Father, knows the conservative justices. So
Right.
President Trump appointed Gorsuch, right?
Mm-hmm.
Kavanaugh, and then Amy Coney Barrett. Those are
Right.
his three
Right.
appointees. But then also serving still is our good friend,
Yes.
Clarence Thomas.
Yes, for a long time.
Long time. And just to say a few words about Clarence Thomas, Justice Thomas, is that, first of all, he has clearly indicated in his writings that he's tired of the Supreme Court being the medical department, right, of America.
Yeah.
And I think he sees a need to get rid of Roe v. Wade. It was
Yes.
poorly written, that decision. It's outdated. And I think he's just waiting for the right thing to come along where we can get the job done. So we know the Trump's three appointees and also Clarence Thomas are in our corner.
Well, Justice Alito is very,
and Justice Alito too.
Very, very good. Very,
very
very
good.
strong.
And the only person that's
well, that's 5. That's a majority.
Right. But that's all we need.
Yeah.
That's all we need. But then there's the Chief Justice, Roberts, who...
Yeah, he's disappointed people in a lot of ways.
Right. But there's still
yet,
hope.
at the same time, he's not the same as the three
left
wing.
No, the 3 left-wing justices. Yeah. Absolutely not. So we have great hope. But let's talk a little bit more so that everyone understands, because they hear about, the Dobbs case, Mississippi. Because I know, Father, I don't think anyone's studied this case more than you have, other than the attorneys themselves. So just for all of us, because even I haven't read up like you have on the case. So explain to what's the law in Mississippi that caused this thing to be fought to the Supreme Court? Let's start with
Mississippi
that.
did something actually that is not unique to Mississippi. A lot of states have been passing laws that protect babies prior to viability. Now, we're going to have to talk a little bit about viability because that's a key concept in this case. But nowadays, medical science puts it at about 22 weeks of pregnancy. Okay. Mississippi passed a law called the Gestational Age Act, protecting these babies from 15 weeks of pregnancy. Now, that's 15 weeks of pregnancy. It's actually 13 weeks from fertilization.
Wow.
And Mississippi said, we're going to protect them starting then. Okay. Other states have passed similar laws. And the court struck it down. The court said it can't be enforced. Why? For one reason and one reason only. The district court in Mississippi, the federal court, into which the pro-abortion people challenged this law, said, we're only going to look at one thing. We're not going to look at all the reasons why Mississippi says we need this law, all the things about the development of the unborn child and that they want to protect, all the things about the harm that abortion brings to women that they want to prevent, all the things about the integrity of the medical profession, that they don't want it to become a barbaric killing profession. We're not going to listen to any of that. Is this law prohibiting abortion prior to viability? And of course, the answer is yes. And the court said, well, that's all we need to know because any prohibition on abortion prior to viability is unconstitutional. So what the Supreme Court has decided to do is to take the case of the Mississippi law and to answer a broader question. And that is, are any and all bans on abortion prior to viability unconstitutional? You see what they've done? They've taken the situation by which the federal court struck down Mississippi's law, they took the reason that they did that, and they're asking, is this a valid reason? Just because it's before viability, does that just nullify the law? Or can the states, on the other hand, legitimately have constitutionally sound reasons for prohibiting abortion before viability? That's the issue, and that's the only question that the Supreme Court is answering. Now, obviously, therefore, that question goes beyond, is the law in Mississippi constitutional? It's asking, are any bans on pre-viability abortion are all bans on pre-viability abortion unconstitutional? So, like I said, there are other states that
like
have
the
done
heartbeat
well
bills.
Even earlier. That's right.
The
That's 6
heartbeat.
weeks into
So
pregnancy.
so if they basically, if they uphold Mississippi's law, they will de facto protect the heartbeat law.
They could,
They
depending
could.
what they say.
Well, how they say it,
Yeah,
right?
yeah. Well,
That-
depending exactly. But it's a pretty sound question. I mean, in other words, legal experts are looking at this and say, well, how can the court raise the question that way and then say, yes, they're all unconstitutional? Because then it's like, okay, no need to hear the case in the first place. In other words, it appears very clear that they're going to change something. They're going to change it something very big. Because remember, now, where is this? Why is viability this drawing line beyond which they can't, before which they can't prohibit abortion? Well, because Roe v. Wade said that, and also Planned Parenthood versus Casey, which reaffirmed Roe v. Wade almost 20 years later. They said, the state can pass certain regulations on abortion because both decisions recognize the state does have an interest in protecting the health of the mother and the life
child
within her.
Right.
The state, in other words, it's a mistake to think that Roe v. Wade made abortion some kind of absolute constitutional right that you cannot touch with a 10-foot pole. It didn't.
But first of all, they've said there is no constitutional right to abortion.
Well, they talked about the right to privacy, and they said this is broad enough to encompass the decision for abortion. But they also said abortion remains a medical decision. Roe v. Wade said the primary responsibility rests not with the mother, but with the physician. And it also said some people say that, the woman has an absolute right to an abortion and the state can't do anything about it. We do not agree with that. Roe v. Wade said that. Planned Parenthood versus Casey went even farther, and it said, look, the states can pass regulations on abortion as long as they don't create an undue burden for women getting an abortion. And they said that the interests of the state, in other words, the reasons that the state would pass laws limiting, regulating, or even prohibiting abortion in certain instances, the states have those interests from the onset of pregnancy. So if the state says, if the legislators say, listen, we have to protect women from the dangers of abortion, that interest can be pursued from the onset of pregnancy. We have an interest in that developing life. Pursue it from the onset of pregnancy. So now the states face this dilemma. On the one hand, the court is saying, yeah, you have interests that you can pursue here. On the other hand, they're tying their hands, saying, but you can't prohibit abortion before viability. So the legislators are saying, well, wait a minute, what is that?
Right.
Let us, if we have these interests, and this is what Mississippi tried to do, we have these interests. Things have changed since Roe v. Wade, and that's a big theme about this case. Things have changed. Science has changed. Culture has changed. Law has changed. Take account of those changes and realize we can't let this unrestricted abortion policy continue.
Well, also, too, Father, viability is like a moving target.
Well, let's talk about that. It is very much a moving target.
I mean, when you think, Father, a decade ago, I think back then, if a baby was born before 25, 26 weeks, it had very little chance.
Roe v. Wade said 28 weeks. Right. And then it admitted, well, sometimes, it could be as early as 24. So right away, in other words, as soon as you say it, you have to qualify it and say, well sometimes it's earlier. Yeah, right. That's why you notice, and some of the briefs in the case point this out, when abortionists advertise how long into the pregnancy they do the procedure, do they ever say viability? No, never. They talk about the specific number of weeks. A lot of
them say 28
weeks, 24 weeks, 22. Yeah. And each abortionist is going to have his or her limit beyond which they're not going to do it, right? So, and some states have the prohibition also. But the point is, viability is a very fluid and vague concept, because what is it measuring? It's measuring, are you talking about the ability of the baby to survive outside the womb? Well, that doesn't just depend on the baby's age. That depends on other circumstances of the baby's health. It depends on circumstances of the mother's health. And it depends on another very big factor. What is waiting on the other side of the womb? In other words, what kind of technology?
Well, that's it. I mean,
And what, not only what kind of technology, what kind of commitment to save that baby.
right.
And in this sense, obviously the technology has progressed, right? We can save these
Right.
babies much earlier today than we were able to in the past. But it's not just that the technology has progressed. What's the philosophy of the doctors working in that particular hospital or institution? You might have two facilities in a city, right? And on one end of the city, they say, well, any child that comes out of the womb before, let's say 24 weeks, we're not going to do anything. We're not going to even try to save that child.
And Father, that
And-
does happen.
Of course.
We've had people contact us
Yeah.
and say, the woman is in the hospital, she's pregnant, and they say, well, you're on bed rest now. If we can get you,
If we can get you beyond this point,
another
right,
week or two,
then we'll do our best.
We'll do our best.
Yeah.
But if somehow
Otherwise, right,
before
we'll just-
that, they'll stand
we'll
back
just keep
and
the
do
baby.
nothing.
Yeah, just let the baby
Comfortable,
die.
comfort care, and let the baby die.
Now, you could have a facility on the other side of the city in which that medical team says, we are going to do everything we can for every baby that comes out of the womb,
Right.
no matter when. So which facility do you think, when you look at the statistics of how early babies can survive when they're delivered early, what's the difference going to be in the statistics? The facility with the commitment to care for those babies is going to have a higher success rate.
Right.
Obviously. So viability. So what is it then? It's not a measurement. It's a prediction,
Right.
taking into account many different factors. And here's the question. What in the world does viability have to do with the Constitution?
Right. Nothing.
There's nothing in the Constitution about viability. As a matter of fact, when Roe v. Wade, threw in this concept of viability as the dividing point before which a state cannot prohibit abortion, it wasn't even in the laws that the court was considering when it took the case. This Roe v. Wade law came out of Texas. Doe v. Bolton law came out of Georgia. Did those laws mention viability? No. When the court heard the oral arguments, and it did so twice for those
There was
cases,
no mention of viability.
no mention of viability there either.
They kind of, when they were
It was
writing the
thrown in.
decision, they threw it
In
in.
the last minute.
Yeah.
So it's in other words, now the court has a chance to look at this and say, you know what, this is meaningless. As a constitutional dividing line, this is meaningless. And I think that's what they're going to say. I don't think they have any other choice but to say that.
All right. So, Father Frank, if they rule in that favor,
Right.
which we think there's a good
Throw
chance,
out the viability.
throw out
line.
viability.
Right.
What does that do? Because is it in fact really overturning Roe v. Wade, or what is it doing to Roe v. Wade?
Well,
exactly?
it kind of depends what they say next. And this is where I have a lot of confidence. We mentioned earlier about the justices, right?
Right.
It's not so much just looking at their view about Roe v. Wade or their view about abortion. You've got to look at their view about the court. And the justices that President Trump appointed, he said, that's my standard. These have to be men and women of the Constitution that recognize that the role of the court is not to legislate.
Right.
That's the role of Congress. The role of the court is to judge. You judge a dispute.
They're supposed to be. I never forget. I was at a talk, Father, and they used this example for us common people that don't understand all these court stuff. They said they're like umpires. They call balls and strikes.
Balls and strikes, right.
That's it.
What is this constitutional? Is it not? All right, it's a matter of judgment. Okay,
Right.
So if they think that a law is unconstitutional, they can't fix it. They have to send it back to the lawmakers and say, hey, guys, try again.
Yeah.
Right. So in answer to your question, it seems to me that if the court says no to the question that they are asking, remember, the question they're asking is, are all bans on abortion prior to viability unconstitutional?
Right.
If they say no,
They're
that
not.
means then at least some of them are constitutional. Now, how do you judge that? That's the question. This is what the lawyers call the standard of review. In other words, if a state passes a law like Mississippi did about abortion, okay, about protecting the unborn, and someone challenges this in court, the question you have to ask is, what's the standard by which the court is going to review and judge that law vis-a-vis the Constitution? What's the standard of review? And there's all these different categories, okay? There's strict scrutiny, which is the highest standard. It's like you can't restrict this so-called right, without a very, very strong, the state has to have a compelling reason, and it has to be the least restrictive way of achieving its interests. Freedom of speech, freedom of religion. These cannot be limited except under this strict scrutiny rule. And some people think, and certain, not a lot, but certain court decisions on abortion tried to put it up there in that category. Court has rejected that. The court has lowered the standard. We mentioned Planned Parenthood versus Casey. They said it has to be a undue burden, okay, that makes a law unconstitutional regarding abortion. But what we're looking for in this case is for them to lower the standard of review even more to what's called a rational basis. In other words, that would be the most, you said before, Justice Thomas and some of the other justices, they don't want the Supreme Court to be a medical review board about abortion.
Right.
Because that's what it is now. Anytime a state passes a law on abortion, it gets challenged in court, they've got to sort it out. But what other medical procedure has that kind of status?
You don't see people.
Are they debating, I don't know,
Heart surgery,
hysterectomies?
Right, no.
They're not.
No.
The states take care of that. Laws regarding medicine are handled, for the most part, by the states. Right. I mean, obviously, there's certain federal laws regarding medicine, but medical procedures don't have a inherent constitutional status. But for whatever reason, this is an anomaly. People have to understand the court has given abortion a special constitutional status. And the problem is all these standards that the courts have given for reviewing whether a law about abortion is constitutional or not are so confusing, they're unworkable. The other judges on all the federal courts, they're looking up at the Supreme Court and saying, hey guys, you're not giving us very good guidance here. One judge disagrees with another, disagrees with a third one, and it's a mess. It's a mess. What's an undue burden? Let me ask you, what's an undue burden? To impose on a woman to get an abortion. What's undue? And what's a burden? There's no definition of that.
Right.
It's going to be a subjective interpretation by the judge. So you don't have a standard constitutional answer to that. This is what we're hoping in this case. It's one thing to say, yes, it could be constitutional to protect these babies. We like to say protect the babies, instead of ban abortion, but it could be constitutional, the court can say, to ban abortion before viability. Okay. But then what do they say next? And that's where everybody's going to, be very interested to see what they end up saying. I think unless they want to be legislators, if they start drawing other lines, if they start drawing other limits, if they say, well, you can ban abortion, but not before 12 weeks. Well, where in the Constitution would they be getting that?
Well, why would they even come up with that?
Well, that would be the business of the legislature.
Right.
If a state wants to say that, well, that's another thing. If Congress wants to say it, that's another thing. I don't think these justices, the majority of these justices sitting on the court now, are going to want to legislate this. And therefore, the best scenario would be let the states decide. And that, you ask, is that a reversal of Roe v. Wade? Essentially, it is. Because Roe v. Wade didn't only take away the right to life of the baby and didn't take it away, it didn't recognize it. But it didn't recognize also the right of the states.
The states, right.
To protect the baby.
Mm-hmm. Yeah, because people don't realize, Father, before Roe v. Wade, there were quite a few states that had abortion already banned. There was only a handful that made it legal.
They had started to change.
They had started,
That's
right.
In the late 60s.
I love pointing out New York. Perfect example. Because New York made it legal before Roe v. Wade. And their ban, only up to 24 weeks, stayed until just a few years ago.
Yeah.
All those years.
Yeah.
But then the pro-aborts got more radical in New York, and they said, no.
Well, once they won the election, once they had the full legislature, once they had a trifecta.
Yeah, the governor and the Senate and the House in New York State, they said, oh, here's our chance.
Yeah.
And now they passed a law that made abortion legal in New York State to birth. But from Roe v. Wade forward, because they actually made it legal a few years before, it stayed all those decades.
And a
all
good
those
number of
decades.
states also still have on the books their pre-Roe v. Wade abortion statutes.
Right.
Because remember, courts can't take laws off the books.
Right.
Only
the
legislatures
legislature
can.
Right.
The courts can say to the state, you can't enforce the law, but the law stays on the books until the legislature changes it.
Right.
So what happens is if this court now takes away that prohibition against enforcing laws protecting these babies, a lot of those laws will just kick right back into effect.
Well, and a perfect example of how this works is in New York State, there was that case of Jennifer Morbelli, who was already in like 33 weeks pregnant, and the doctor, her OBGYN, when this was a wanted baby, said that the baby's going to have a seizure disorder, blah, blah, blah. But because he couldn't send her to an abortionist in New York State because she was beyond 24 weeks, he sent her down to Maryland, where late-term abortionist Leo Carhart works. Leroy Carhart, and therefore she got her abortion there. So as you know, all these laws, like you said, Father, are already out there in different states with the number of weeks that they've always permitted. Like New Mexico is another state where they have late-term abortion. Like people, does late-term abortion really happen? Yes.
Third trimester
and that's
abortions,
why
yes.
when we say Roe v. Wade, Doe v. Bolton made abortion legal through all 9 months of pregnancy, that's what we're referring to, that a state had the right to change their laws all the way to birth. Like New York did, and now Vermont and a few others, you know?
Right. Yeah, that's right.
So,
because Roe v. Wade said they could.
Right.
They said they could permit it right up until birth.
So if the Supreme Court rules the way you're describing, then does that put it, it really throws it back then to the state laws, doesn't it?
It would, yes.
It would dismantle Roe, right?
Yeah, it really
and Casey too, in one swoop, right?
Right, yeah, and right, exactly. In other words, unless they're going to clarify the undue burden standard, they can just toss it out. They can say, look, this is, because one of the key arguments that's made in a lot of the briefs is that it's unworkable. Unworkability is another key theme that these attorneys and these justices look at. Is the guidance we gave before workable or unworkable? Is it giving a solution to the lower courts? Because remember, the lower courts have to apply what the Supreme Court says on if they're ruling on the same issue.
Right.
That's called vertical precedent. Horizontal precedent, the Supreme Court does not have to abide by its previous decisions. That's why it can change things.
Right.
It can change Roe v. Wade. But the lower courts, they can protest against it, but they have to apply its decision in the cases they decide on the same issue. So what the question of workability is as these judges apply the Supreme Court decisions and guidance, is it working? Is it giving them a clear solution, or is it creating confusion? There is no doubt. I mean, this is not a matter of opinion. It's a matter of measurable fact. It's creating confusion. And on that basis, the court can say, well, we're going to throw out this, quote, undue burden standard because it doesn't make any sense. Now, they're going to replace it with a new standard. I mean, again, I think the best solution is rational basis. Does the state have a reasonable, reason for its law? Then let it go ahead and legislate.
Right. So now, with this case, Father, as we know, amicus briefs have been written.
Yes, many
on both sides, on the pro-life side, pro-abortion.
Right.
So, do you know how many wrote it on the pro-abortion side?
There
Approximately,
were less than the pro-life side. The pro-life side, there were about 80.
Really?
And I heard recently the pro-abortion side, there were about 50.
Oh, look at that. But here at Priest for Life, of course, I'm holding
There's
in my
ours.
hand.
Yeah.
This is our brief, right?
right.
Here we go. Can you give our viewers here a little synopsis? Of,
Yes. Well, what I mentioned before, the courts have already acknowledged that the states have certain interests they can pursue in the arena of abortion.
Right.
And one of the big ones is the health of the mother. And because we oversee Rachel's Vineyard, I'm the chairman and pastoral director of Rachel's Vineyard. It's a ministry of Priests for Life. And this is the largest ministry, as you know, for healing after abortion.
That's
and
right.
you co-founded Silent No More, which helps the women after abortion as well.
Speak
and many,
out.
they share their testimonies.
Right.
We brought the voices of those women to the court in this brief. And we said, because the state has an interest in protecting these women, and by the way, we're going to show you now the damage that they endured from abortion, therefore, the court should allow the states to do so. And that's our argument in a nutshell. And that brief mostly consists of the appendix. The arguments are short.
Right.
The most of that booklet you're holding is an appendix of those testimonies of women harmed by abortion.
Yeah, I'm going to flip to it now, and here it is. Like, look at this, brothers and sisters. See the thickest part here?
Yeah.
That's all the testimonies,
testimonies.
and the big is the legal beagle arguments from the lawyers. So, I mean, but explain to people amicus briefs.
Yeah.
Okay, they go up to the court.
Yeah.
What happens to them? Who reads?
The
clerks?
Staff. The clerks of
The
the.
clerks
I mean, the
of-
justices obviously can read however much they're able to read, and the clerks are tasked with reading and studying these briefs. The briefs are, in other words, there is a brief, the main brief, from each of the parties. So the state of Mississippi issued a brief,
Right.
nice thick document making all the legal arguments. The abortion facility, Jackson, which by the way is the only abortion facility
Left in Mississippi. There's only one.
Right. They obviously submitted a brief. Okay. Remember, Mississippi is the petitioner. It's Dobbs versus Jackson Women's Health Organization. Dobbs is the state health official in Mississippi.
Oh, I see.
So it's Mississippi taking the initiative. Mississippi knocked on the door of the court. Hey, we've got a problem here. We want to defend our law. Then the abortion facility then had to respond. So they submitted a main brief in response. So the arguments of both sides, okay, are contained in these two main briefs. Amicus briefs, amicus is the Latin word for friend. So amicus curiae means friend of the court. So we're friends. We're friends of the pro-lifers in Mississippi, and many other groups are as well. And so we come knocking at the door of the court also, and we say, hey, we want to make some supporting arguments. We want to speak in favor
of
the arguments that
to
add to it. Right. And the briefs are beautiful. I mean, they are really an array.
All right, so Father, of the 80, how many have you read?
I've read them all.
All 80?
Yeah.
Oh my goodness. So if you were to look at all 80 briefs, and I said, and I'm the Chief Justice, and I said, okay, Pavone,
yes, right.
Give me 5 facts. What's the 5 facts from those 80 briefs you can glean for me? Like, what are the 5 most important things you could tell me?
Well, what I said before about the standards the court has given are unworkable, including viability. That's point number. The undue burden is unworkable. Viability is meaningless constitutionally.
These are what the briefs are kind of saying.
Yes, the states have interests in. You've already told us the states have interests in protecting the unborn life and the health of the mother. Let them pursue those interests. Their hands are being tied here. And then a big point of things have changed. Things have changed in medicine. We know more about this child than we ever did before.
Well, right there, Father. Yeah, stop for a second, because people have to realize, and the younger people may not get this, but at the time of Roe v. Wade, ultrasound was not really used that much.
No,
every
it wasn't widely
OBGYN
used.
did not even have an ultrasound machine. It was brand new technology.
We have now not only ultrasound, but once you can see the baby, you can diagnose and treat the baby. So we have fetal surgery, we have fetal diagnosis and therapy. There's a medical journal. I get a subscription to it, actually. Fetal diagnosis and therapy. The baby is our newest patient.
Right.
So one of the key arguments, a lot of the briefs make this argument. One of the key arguments to the court is, hey, things have changed medically. Take a look at this child. You can't just ignore it and say, oh, it's before viability. Because what's there before viability, we know more about now than we ever knew before. Take a look. So that's one of the big arguments. Science has changed. Law has changed. Roe v. Wade said, oh, it'll be a big inconvenience for the pregnant woman to, have to carry that baby to term. What are you talking about, a big inconvenience? Now we have so much more to protect pregnant women from discrimination, including in the workplace. So many more opportunities to pursue online learning and online at-home work opportunities than was at the time of Roe v. Wade. The internet did not exist. And we have so much more in terms of, like, for example, the safe haven laws.
And that
some of these briefs talk about.
That is a beautiful law, Father. That's in all 50 states. And it means any woman giving birth to that child, they can walk out of the hospital and say, I've changed my mind.
Right.
I don't want this baby. The state, you have it.
That's right. And that's it. No questions asked.
Right.
Didn't exist at the time of Roe v. Wade. So, and just culturally, the acceptance of out of wedlock pregnancy, motherhood, and it's different now than it was at that time. Plus, some of the briefs point out the fact that the advancement of women in society has happened independent of the legalization of abortion.
Right.
The other side tries to say, oh, got to keep abortion legal because, women have to advance in society. What are you talking about? They don't need abortion in order to advance in society. So the briefs point that out. The cultural changes are big.
And so, Father,
so these are the points I would make.
Okay, so there's a website they can go to if you want to read all the
Read
briefs.
the
We have them
briefs.
there. What's the website?
SupremeCourtVictory.com.
Okay.
It's our website,
Mhm.
SupremeCourtVictory.com. Not only can they read the text of the briefs, they can see videos of me interviewing a lot of the people that wrote those briefs.
Right,
And
and
we
also
discuss-
too, there's prayers there too.
Oh yes, we have been spearheading a national prayer campaign
That's right.
for victory in this case.
Well, Father, thank you for a great discussion. And I hope, brothers and sisters, now you know a lot more about this great case. The oral arguments are going to be December 1st. A lot to tune into. You're going to tune into endabortion.tv because on that day, we are going to have live coverage here on our channel right from the Supreme Court. So thank you for joining us on Just Ask Janet. And remember, just go to SupremeCourtVictory.com. All the information will be there. This is Janet Moreno, Executive Director, and Father Frank Pavone. Thank you, and God bless.